Someone calls a law unconstitutional. You hear it in conversation, in the news, in political debate. But what exactly are they claiming? The word gets thrown around loosely, yet it has a specific legal meaning, one that matters. Unconstitutional means a law, action, or policy directly contradicts something written in the Constitution or its amendments. Not merely unpopular, not simply unwise, actually incompatible with the document's text or its underlying structure. Consider a straightforward example. Congress passes a law banning certain religious speech. This directly violates the First Amendment's protection of free exercise of religion. The conflict is textual and clear. No court needs to stretch to find the problem. The Constitution says one thing, the law does another, but unconstitutional claims extend beyond explicit words on a page. The Constitution also establishes how government works, the separation of powers, the division between state and federal authority, the checks one branch places on another. A president cannot unilaterally declare war because the Constitution reserves that power to Congress. The structure itself forbids it. The Constitution protects rights too: speech, assembly, due process, equal protection. When government infringes these rights without proper justification, courts may declare the action unconstitutional. Yet this is where interpretation becomes crucial. Courts, the Supreme Court and lower federal courts, decide whether something is truly unconstitutional. A law might appear to fit the Constitution's text on first reading, but courts often uncover hidden constitutional problems through careful analysis. Their interpretations shape what the Constitution means in practice. Over decades, even centuries, courts have broadened and narrowed what counts as unconstitutional as they reconsider old cases and apply old text to new circumstances. This distinction matters in everyday life. Two people might oppose the same gun regulation. One argues it violates the Second Amendment, an unconstitutional restriction. Another argues it simply won't work as policy, that it's ineffective or unwise. These are entirely different claims. Only the first invokes constitutional law. A law can be bad policy, unpopular, or morally objectionable without being unconstitutional. Disliking a law is not the same as proving it violates the Constitution. The term marks something more specific, a genuine legal conflict between a government action and the Constitution itself, as courts understand it. That precision carries real consequences. Courts can strike down unconstitutional laws. Citizens can challenge government actions in court on constitutional grounds, but those arguments only work if an actual constitutional violation exists. Unpopularity alone won't do it. So when you hear the word unconstitutional, listen for whether the claim rests on the Constitution's text, its structure, or its protections. That's where the legal weight lies.